Get ready with me while I talk about parental alienation in family court. Any family law attorney that tells you proving family alienation in family court is easy is lying to you. Exercise a little bit of caution before hiring that attorney because it is not an easy thing to prove in family court. However, it's not impossible. I have proven it. I have won cases based on parental alienation. I've also lost cases based on parental alienation. Here's some guidance on how to win a case, how to make a case for parental alienation, and how to win it in court. The number one thing I use in proving an alienation case are texts between the parties. Texts between plaintiff and defendant are considered a hearsay exception, meaning that they are wholly admissible. So text messages between mom and mom, dad and dad, however it is, those are admissible in your family court case. And those can be so useful when proving parental alienation. So what are some things that I would look out for in text? I would look out for threats regarding the children, conclusive statements about the child's interest in seeing the other parents. If a parent says, for example, our child would never want to see you because she knows what you did. Red flag. Why does the child know what the other parent did? That's the question you need to look into. If the child knows that because of the other parent sharing information, that is a good indicator of alienation. Now, it doesn't just take this one piece of evidence. You need to have a lot of different pieces of evidence to round out your case. Another way you can use text to prove parental alienation in family court is text like this. Let's say one parent is saying, I asked the child what they want to do and they want nothing to do with you. Why are they asking the child? Red flag. They shouldn't be incorporating the child into adult decisions. It is a small indicator for parental alienation, but building up all of these indicators and compiling them and providing all of that to the court, it's almost like making a case based on circumstantial evidence, because you'll never have a party accused of alienation just say, woe is me, I alienated the child. Of course not. And some other pieces of evidence the court might use to find alienation in a case might be report cards, and your teacher is writing comments on the child's behavior, things like that. The teacher has noticed certain behaviors, their struggles in school. They might put that in a report card. They might also show doing poorly in school as a reflection of the stress that has been created by the other parent. Things like that can be shown by using report cards in court. Another underrated piece of evidence that people don't think about is witness testimony. You can have third parties, specifically ones that know both you and the other parent or have direct knowledge of the child. You can have them come and testify on your behalf and testify as to their account of some of this alienation. The witness can testify as to what that party said because it's that hearsay exception. Lastly, a great tool to use in an alienation case, if your court will grant you one, is a guardian ad litem. What that is an attorney for the child. They have the ability to speak to the child. The parents, all their therapists, teachers, whoever they find necessary to speak to. Then they go to the court and they report back. Basically, the guardian ad litem will say what the child's interests are, what the child wants, and then they will say why they find that to be credible or why they think that child is being alienated or not alienated. A guardian ad litem is a really, really helpful tool to get the point of view of the child into court. One more reason why a guardian ad litem can be so great in your case is because, at all possible, I think it's always my last resort is to include a kid in a court case, especially a kid that's younger. I think at all age it can be very damaging, but especially when a kid is young, having any involvement in the court case. I always say that a child should have no business knowing anything that's going on in court. And ideally, that's what you want. And a guardian ad litem can allow you to maintain that while also incorporating that child's point of view and what they want and what they're experiencing. All of these things can be used in conjunction with one another and hopefully provide a compelling case to the court and win you an alienation case. Again, alienation cases are not easy. Courts are just now starting to acknowledge that alienation is an actual issue. Over the past probably decade, courts have been hearing about it much more and starting to acknowledge it and accept it. And over time, it's just getting better and better. And so still there are courts that are a little bit further behind. And so you might make a perfect alienation case and still lose. But the benefit of making an alienation case is when you have an alienated child, only people that have been there know what I'm saying. You have no other options. Your only way is to try your very, very best to get through the alienation and reach your child again. And I tell people your number one best fight against alienation is showing up in consistency. And going through court, trying to prove your case is oftentimes a great way to show your child that consistency. So yeah, let me know if you want to know more information about parental alienation. If there's any other topics you want me to cover, I'd be happy to.